Continuing the RICO cases in this section, we've got supreme.justia.com, got HJ Incorporated versus N.W. Bell Telephone Company in 1988, 1989. Got the Northwestern Bell Telephone Company and HJ Incorporated. So this is the Racketeering, Influence, and Corrupt Organizations Act, 18 U.S.C. 1961 to 68, which is Title 9 of the Organized Crime Control Act of 1970, OCCA, imposes a criminal civil liability upon persons who engage in certain prohibited activities, each of which is defined to include as necessary element proof of pattern of racketeering activity. 1962. Racketeering activity means any act or threat involving specified state law crimes that any act indictable under specific federal statutes and federal offenses. 1961-1. A pattern requires at least 2 acts of racketeering activity within a 10-year period. 1961-5. Petitioners, customers, and respondents of Northwestern Bell filed a civil action in the district court at Northwestern Bell and other respondents, including members of the Minnesota Public Utilities Commission, is responsible for determining Northwest Bell's rates, seeking an injustice and treble damages. It raised 4 separate claims under 1962A, B, C, and D, based on the factual allegations that between 1980 and 1986, Northwestern Bell made various cash and in-kind payments with the NPUC members, and thereby influenced them to approve rates for the company in excess of fair and reasonable amount. This district court dismissed the complaint under the Federal Rule Civil Procedure 12b-6 for failure to state a claim upon which relief could be granted on the ground that each of the fraudulent activities alleged was committed in furtherance of a single scheme to influence NPUC commissioners, rather than multiple illegal schemes. The Court of Appeals affirmed, confirming that under its precedence, a single scheme is insufficient to establish a pattern of racketeering activity. But what was held? 1. In order to prove a pattern of racketeering activity, a plaintiff or prosecutor must show at least 2 racketeering predicates that are related to, that amount to, or threaten the likelihood of continued criminal activity. Proof of neither relationship nor continuity requiring showing the racketeering predicates were committed in furtherance of multiple crime schemes. And A. Section 1961-5 states at least 2 racketeering predicates committed within a 10-year period are necessary to establish a RICO pattern, but implies that 2 acts may not be sufficient. Section 1961-5 thus assumes that there is something to a pattern beyond merely the number of predicates involved. In normal uses of the word pattern, it would also be taken to require not simply a multiplicity of predicates, but rather predicates that range in order to the reason of the relationship to bear such to order external organizing principle. The text of RICO fails to identify the forms of relationship or external principles to be used for determining whether predicates fall into a pattern. RICO's legislative history, however, establishes that Congress intends to prove that a pattern of racketeering activity, a plaintiff or prosecutor must show both relationship and continuity, that the racketeering predicates are related, and that they constitute the threatened long-term criminal activity. B. Relationship and continuity are 2 distinct requirements, though their proof will often overlap. RICO's notion of relationship is no more constrained than the use of Title 10 of OCCA, under which criminal conduct forms a pattern of if it embraces criminal activity and has the same or similar purposes, results, participants, victims, or methods of commission, or otherwise irrelated by distinguishing characteristics and are not isolated events. 18 U.S.C. 3575E. Continuity of racketeering activity likewise may be demonstrated in a variety of ways. Continuity is centrally a temporal concept and may be either disclosed or open-ended. A party alleging a RICO violation may be demonstrated in continuity over a closed period by proving series of related predicates extending over a substantial period of time. Otherwise, it must be shown that the predicates establish a threat of long-term racketeering activities. For example, because the predicates themselves involve a distinct threat or such activity, because they are part of the regular way of doing business for an ongoing entity, such as criminal association or legitimate business, or because they are regular means of participating in ongoing RICO enterprise. Although proof of multiple criminal schemes may be relevant to this query to continuity, it is not the only way to show continuity. Adopting the Court's Appeals multiple scheme test would bring rigidity to the method of continuing a pattern not present in the idea of continuity itself. And it would introduce a concept, the scheme, that does not appear in RICO's language or legislative history. Neither RICO's language or its legislative history supports a rule that the defendant's racketeering activities form a pattern only if they are characteristics of organized crime. No such restriction appears in RICO's text, nor is there any language suggesting that RICO's scope should be limited to an association rather than an individual acting alone. Moreover, Congress' approach in RICO can be contrasted with its decision to enact explicit limitations to organized crime or in other statutes. For example, Omnibus Crime Control and Safe Streets of 1968 Act. 601B, the 601B. The argument that RICO's broad language should be read restrictively to be congruous with the RICO's purpose to eradicate organized crime is rejected. The legislative history shows Congress had no such restriction in mind. 2. The Court of Appeals erred in affirming that the district courts dismissed petitioner's complaint for failure to allege facts sufficient to demonstrate a pattern of racketeering activity. Consistent with the allegations in their complaint, petitioners may be able to prove that the multiple predicates alleged satisfy the requirements of continuity and relationship, and hence satisfying RICO's pattern of racketeering element. Lastly, got the 829F2D with 648 reversed and remanded. You've got your Brennan J. delivered the courts as well for your reference, and you've got your opinions on either one. Go